The criminal law and procedure question from February of 2006 is one of the easiest essay questions to appear on any recent California bar examination. This is an easy question because it is testing simple issues in a very straightforward way. This isn't really an essay question. This is 4 short answer questions, and we have an hour to write it. Have a look at the call of the question. How should the judge rule on the following motions made by Deft at trial? 1. To suppress the cocaine. Discuss. Well, we don't even have to read the fact pattern to know that more than likely the Fourth Amendment is going to be at issue here. Question 2. To suppress Oscar's identification during the lineup. Discuss. Well, that's a fairly narrow issue, and it may be one that we're not expert in. But this would be a good time to become an expert, and this question may help you learn a little bit of law if you didn't know it already. Question 3. To suppress Deft's admission that he struck Oscar. Discuss. Well, we've seen this issue before in many other questions from this subject, and almost always, when we've got an admission, we've got a Fifth Amendment issue. And then, finally, question 4, for an instruction to the jury that Deft's assault was justified on the basis of defense of another. Discuss. Well, we're going to have to look at the facts in order to make a judgment about this. But question 4 appears to be another narrow and specific question that we should be able to give a straight answer to. Now go to the top of the question, and you'll see that we meet the cast of characters pretty quickly. Deft sees Oscar, a uniformed police officer, attempting to arrest Friend. Friend is resisting arrest. Deft strikes Oscar and ends up freeing Friend and himself, and they both escape. In paragraph 2, Paula, another police officer, arrests Deft as a result of knowing the precise description from Oscar. She finds drugs on Deft. Now, let's just stop for a moment. Question 1 asks us about this cocaine. Assuming we don't get any additional information, should this cocaine be suppressed? Answer, no, because we've got a search incident to a lawful arrest. Do you see any problem with this arrest? If not, there's no problem with this very simple search. So the cocaine almost certainly will get admitted. Let's keep reading. We've got Paula giving proper Miranda warnings. Deft says he wants to talk to a lawyer before answering questions. Paula doesn't interrogate him. Fair enough. So far, it looks as if the officer is doing her job. But before an attorney can be appointed, we've got a lineup. That gives us a Sixth Amendment issue. It also technically can give us a Fifth Amendment issue, as you'll see, but primarily this is a Sixth Amendment issue. And at this lineup, Oscar identifies Deft. And then we get call up to question number 2 with regard to whether or not this identification ought to be suppressed. Answer, yes, because we have no lawyer present, and this would be a stage in which a lawyer would be appropriate. Then we've got the charge placed against the defendant after this identification, and he's arraigned. Then Officer Paula comes back. She gives warnings, Miranda warnings, again, gets a waiver, and then we get the admission. Call up the question 3. Should this admission be suppressed? Answer, yes, because we've got a defendant who already has invoked Miranda. Fair enough. Well, it looks like a pretty simple, straightforward question. Turn the page and take a look at the outline of issues that I've presented. And here again, you'll see that what I'm doing here is strikingly similar to what I've done in other criminal law and procedure questions. I give a straight answer to each one of the 4 questions on the basis of serious and thorough analysis. With regard to question 1, we see that it is a Fourth Amendment issue. I lead with that. Then I go into the key facts about the warrantless nature of this search, and then the exception, the search incident to a lawful arrest. And that justifies the officers searching Deft without a warrant. So I conclude that the cocaine is coming in. With regard to the identification, I talk about the right to counsel, the Fifth and Sixth Amendments separately, and then I arrive at the conclusion that the ID ought to be suppressed. Is that going to prevent this witness from identifying the defendant at trial? Answer, almost certainly not. We turn to question 3, and here, with regard to the admission, Obviously, it's a Fifth Amendment issue, but it also can be considered a Sixth Amendment issue since we have a defendant that already has invoked Miranda. Then, finally, we turn to question 4, the jury instruction, and here, the defense of another instruction would basically constitute instructing the jury to acquit the defendant. We conclude that this jury instruction ought to be denied by the court. So we've got a simple question that sets up as 4 short answer questions that really are pretty independent of one another, and they're easy to organize. But it's important to take the time to organize carefully and then to try to think up all of the applicable details. The Fifth and Sixth Amendment rights to counsel really are slightly different from one another. And with regard to the self-incrimination issue in question 3, there's also a tiny right to counsel issue present there. And adding those details makes one's answer superior to what it would be otherwise. When we get short answer questions like this, we really are obligated to go into as much depth as possible. So with that in mind, now let's have a look at my model answer to this question. And you'll see that I find a home for every fact, and I also find room for maybe an unusual amount of law. Take a look at my answer to call of the question number 1. With regard to the cocaine, I lead with a heading that indicates what the result ought to be. Remember what the question presented was, how should the judge rule in the motion to suppress the cocaine? Well, my heading is, the judge should deny DEF's motion to suppress. Then we go into the Fourth Amendment. I explain what happened. I lead with the facts, and then I explain what the Fourth Amendment is. And I think you'll have to agree that this is a very complete definition of the Fourth Amendment. And you'll also see that I apply it to the facts of the case that we are discussing. This is an example of showing the grader where the law and the facts touch. It isn't boilerplate. So I go into the facts surrounding the actual search. It's a warrantless search, but it's a search that is incident to a lawful arrest. So I conclude that the judge ought to deny the motion to suppress. And I really don't think that a reasonable applicant can arrive at a different conclusion. I just don't see how a colorable claim can be made that DEF's Fourth Amendment rights were violated by this search. Now, the rest of my answer is a lot more sympathetic to the defendant, although I think we all can see that it's obvious that in the end, the defendant will be convicted of the charge that he's facing. So let's consider my answer to question 2, the motion to suppress the identification. Again, as you look at the heading, you'll see that I am leading with a straight answer to the simple question that was presented. One thing that I think is stylistically appropriate when we get a fact pattern that has such narrow and specific questions. I do think it's appropriate to give a narrow, specific answer up front. Is it required? Certainly not. There's no right way to do this. Our job is to show our disinterested, chain-smoking solo practitioner that we know what we're doing. And I think that one way to make that showing in answering a question like this one is by giving a straight answer. So I lead off with a heading that the judge should grant the motion to suppress the ID. Then I lead with the facts that set up this motion, and I explain what the Fifth Amendment right to counsel is, and then clearly this is fundamentally a Sixth Amendment question, and I go into that in much more depth. So finally, I conclude that the judge ought to suppress Oscar's identification from the lineup, but that Oscar ought to be allowed to testify at trial. And presumably, he'll be able to identify the defendant. That will almost certainly result in the defendant's conviction. Then we turn to consider my answer to call of the question number 3. Again, my heading is a straight answer to the question presented. So I lead off my answer to number 3 with the heading that the judge should grant the defendant's motion to suppress DEF's admission that he struck Oscar. Below that, I lead with the facts, and then I go into some depth about the Fifth Amendment right against self-incrimination, both its constitutional origin and the Miranda case. And I go into great detail about all the different facts that transpired. The paragraphs here in Miranda might be the most analytical ones in this answer. I have a brief discussion of the Sixth Amendment right to counsel as well, and I conclude that the judge ought to grant the motion to suppress the admission. Finally, let's turn and have a look at a straight answer to the fourth question presented. And once again, my heading is that straight answer to that comparatively straight question. The judge should deny Deft's motion for the jury instruction. And notice up front that I lead with the facts and I explain what happened. Then I go into some depth about the proposed jury instruction. The language of the instruction isn't fair to the prosecution. On its face, it's just wrong. Then I go into the substance of the defendant's defense of another defense. And it's obvious that this jury instruction is inappropriate. In the end, though, I conclude that the judge ought to deny the motion for this jury instruction, but I also indicate that it wouldn't be an abuse of discretion for the judge to give some alternate jury instruction on the point, but it couldn't give one that basically constituted a directed verdict for the defense. And that wraps up a consideration of one of the most simple, straightforward essay questions that you will ever see on a California bar examination.